tell you, I've been waiting for a long time for another Duggar boy to get married and have a sister-in-law, and so I'm just thrilled to have you, Kendra, as my new sister-in-law, and we look forward to lots of double dates in the future. And
so that's 2 out of the 10 boys now that are married, and there's a lot more to go. There's a lot more Duggar weddings in the future, but it's nice to have another Duggar sister. So we're carrying on that last name.
Y'all, this is wild. Like, I was not expecting to read this. It's Katie. Welcome to my channel. I'm having one of those days where I noticed that some documents were filed in the Joanna, Jill, Jessa, Ginger lawsuit against the city of Springdale and the defendants in the case of Kathy O'Kelly, Ernest Kate, Rick Hoyt, and Steve Ziga. Or the 4 government workers, and then the city of Springdale of Arkansas and Washington County. And a couple weeks ago, I told you about how the defendants wanted access to records that they claimed that the Department of Human Services had. And they wanted all of these records because they claimed they needed these records in order for their defense to basically determine whether or not what Josh had done to his sisters, whether or not it was actually private or if people publicly knew about what was going on. And now they've disclosed why they want these documents. And it's kind of shattering to me, like earth-shattering. Like, I had no idea that this was a fact. And I still don't know if it's a fact. But so basically DHS said, we can't release this information to you guys because it's confidential. We would be violating this specific law in the state of Arkansas. And by doing so, we would not be able to, like, we're in a lawsuit about privacy and you're asking us to invade the privacy, potentially breaking state laws, you know what I mean? And so they wanted it quashed and they wanted to not have to provide these documents. And the argument made by the defendants in this case is that they believe that they filed this late, which I don't know if they actually do. They claim that it's material in their defense. So they say the claims against Springdale defendants is the allegation that the stuff that Josh did, the CSA that Josh did, was private information not within the public knowledge. They say upon information and belief, after a call to the Arkansas Child CAH, the hotline on December 6, 2006, several state agencies, including DHS, were involved in the investigations of the claims and therefore would have relevant information to the Springdale defendants' assertion that the facts surrounding the plaintiff's case was within the public knowledge prior to the release of the redacted Springdale report. So they're claiming that all these different agencies got involved and there was a public investigation that happened. So they believe that this wasn't private information after this was released. Like, people in the area knew what was going on. But they also say this. They say the defendants have a substantial and compelling need for the documentation and possession of DHS. Upon information and belief, Josh Duggar was placed on the offender registry, and a legal proceeding was undertaken to remove Josh Duggar from the offender registry. The defendants are entitled to this information and documentation due to one of the central elements of the plaintiff's claim being public disclosure of private information. If Josh Duggar was placed on the offender registry, other information such as the different crimes he would have committed, whether or not involved like a family member or a non-family member, and other identifying information could have led to the disclosure of information plaintiff's claim was private and not known to the public. Additionally, correspondence between Josh Duggar and or his agents in the possession of DHS regarding his removal from this registry could provide information as to the public knowledge of his acts of what he did to his sisters. Basically what they're saying, you guys, to break this down into like easy to digest words, is that in the National Registry and the State Registry, when somebody does what Josh does, they can be placed on this registry, and then that is public. And you can go into the registry and search the registry and find somebody's name on the registry, and then it will tell you details about the victim. Now, it won't say who they are. It will say non-relative minor or something like that, or relative minor, so that the information gives you an understanding of not who they did this to, but the connection they had to that person. Was it a family member, a non-family member? And so what they're saying is, so they believe that Josh was on this registry. They also believe that Josh and whoever else took steps to remove him from the registry, and they claim that he was removed. And they claim that because he was on this registry, it wasn't private. That people in the area would have known if they checked the registry. That people could have looked them up on the registry, seen who he did this to, whether connections are family or non-family members, and like if it was minor, non-minor, right? So if he's on that registry, it wouldn't have been private. So their argument is that they want to make sure, because they have compelling belief that he was on there, that he was removed from there, and that therefore, because he was on there, the public knew or could have, their right to privacy regarding this becomes moot at that point simply because he was on the registry. It's never been widely discussed whether or not he was on the registry. We only know that at the end of the investigation, they did not move forward with charges. Now, could an agreement have been that we aren't going to prosecute you, but because you've admitted to this, we are going to place you on the registry, and that way the public can be safe from what you've done, that you've acknowledged that you've done, and they've said they were outside of the statute of limitations for prosecuting him. Could that have been sort of a agreement that he came up with law enforcement, a judge, whatever? Prosecutors may have offered him that in lieu of charges, perhaps. But it's never been discussed, this. And it always made me wonder if he was ever on this. And this is literally the first time in black and white I'm seeing something that says that he might have been on it. They have substantial and compelling need because they believe that he was on this registry. If he was on that registry, it literally changes everything. All of Jim Bob's arguments and arrogance and complete and utter like disdain for the government, stating that they had it in for him and they did this at the end because they had it in for him. Why would he say that about a government agency if they never formally pressed charges, unless he himself was angry at them for something or he wanted to pass blame onto them? He's always stated that Kathy O'Kelly has gone and had this vendetta against his family. What if Josh was on the registry? What if they somehow were able to finagle a way to get him off the registry? Like, say he had to be on the registry for X amount of years without reoffending, and then they were going to take him off. Because you're not always on the registry for like a lifetime. If he was on the registry, that means, again, anyone could have looked him up on the registry during that time. It would have been publicly accessible knowledge, information about the crimes, and to a certain extent would have been available to the public, and thus making the whole argument that their privacy was violated by the Freedom of Information Act being released through a legal request to the state or to the county. So according to the state of Arkansas, anyone who's convicted of a certain offense would be, specifically ones against children, are required to register. It says any individual who was incarcerated on probation or parole, or serving any form of community supervision as a result of an adjudication of guilt for the listed offenses as of the act's effective date. Any person who is acquitted on the grounds of mental disease or defect for the listed offenses. Any person who was required to register under the Habitual Act of Arkansas, or a offender that's moving to or returning to the state from another jurisdiction. There's 3 separate levels. They have a level 1, which is for offenders that have no prior history, and the community can be protected with notification inside the home and to local law enforcement. Then there's level 2, which are people that have a history of doing it, and notification inside the home is insufficient, and community notification requires notice to the offender's known preference and those likely to come into contact with the offender. And then they say the level 3 are ones that have a repeated history of doing it. And so my guess is perhaps because it was habitual in nature and it was more than once, maybe this was something that they placed him on for a short period of time and then he had it removed or something. But the fact that they claim that he was on this is wild to me. I have often wondered if he ever was. And these are the first government workers going on record saying they believe he was on this. They believe he was removed, and they want that evidence to prove that his crimes were publicly known and accessible, and therefore what they did was not a violation because it was already out in the public. If that's true, this literally changes everything. And that also makes me wonder, if he was on the registry, how the hell did they get him off of it? What kind of strings did they have to pull to do that? What are your thoughts about this? Do you believe he was on the registry? Do you believe, given that, they should have access to those documents? Now, the DHS responded and said that doesn't matter. We still should not have to give up this information. They're going to fight this all the way to the end. What do you think the court will decide? Do you think we'll ever find out if Josh was on that registry? Tell me in the comments below. Bye, guys.